are appeals in the matter of J. MSK v. FC Children.
Yes, Ms. Briggs.
My lords, my lady, these are the appeals in Re J, Re M and Re P.
Yes.
There is a comprehensive list of all counsel and solicitors.
Yes.
Tabular form, which has been put before my lords and my lady earlier today.
And for the purposes of anyone watching on the live stream, we have a select group of counsel in this courtroom, but it's by no means all of the counsel in the case. My understanding is that the others are in an adjacent courtroom watching on either the live stream or a CVP link. We hesitated before coming in because we understand that some of the interpreters are remote.
Yes.
And need to be online, and the link was only sent to them relatively shortly. I don't know whether anyone in this room is connected with those cases with the interpreters, but we're assuming that that's happened, and so we've come in to start the hearing.
My lord, yes. I am in contact with some of those in that appeal, which is Re P.
Yes.
None of them are present in the courtroom.
No.
But no doubt they will.
Well, I've said what I've said, so that if there is a problem, they can make contact with the court staff and let me know. We should apologise for the late start. It was entirely due to multiple transport difficulties that one of the members of the court had, and I'm very sorry that you will have been inconvenienced, and particularly the parties will have been geared up for starting at 11:30, and here we are at 1:30 now. So the plan is to sit now without a break unless we need one till 4 o'clock, when I'm afraid we have to rise at 4. But we're relatively comfortable that we've got enough time over the 3 days. I also ought to apologise for the fact that it was brought forward a day. That's because, very sadly, I've got to attend a funeral that I must attend on Thursday. So that's the explanations and apologies out of the way. We're extremely grateful, and that's sincerely meant. Of course, it's always sincerely meant, but in this case, it actually is meant, to all of you for the skeleton arguments that have been produced. They're extremely thorough. And certainly for my part, I'm also grateful to the 3 judges who produced judgments which set out the issues and their approach to them very clearly. And we three have read all of that material, and so plainly you going first should have the opportunity to set out your case as fully as you would wish, and the others going first. But we hope that there isn't going to be a necessity for each party who is ploughing the same furrow, or whichever side of the argument that is, to start from scratch.
No. My lord, may I just pause a moment, because I'm being told that those in the overflow courtroom are not able to hear us.
Sorry, Laura, it's not the overflow, it's the CVP link, I've just been told.
I see. The CVP link are not able to hear us.
Or see us.
Or see us, I'm told.
Right.
So, my lord and my lady, would you like to rise while we try to sort those difficulties out?
Is that what we should do? Yeah. Good, we'll do that.
All rise if able.
Sorry, we said that was only
She can't see or hear.
Okay, Connie's fine, Joe.
Sorry?
Connie.
The Connie's got it, it's just a bit.
So she got it. I don't know if that means it worked. She got it.
All rise if able.
Oh, there we go. I gather now it's working, and we can proceed.
So, my lord, my lady, shall I introduce counsel who are present in this room
That would be helpful.
before
Yes.
proceeding? So, I, with my learned juniors, Miss Liz Andrews and Miss Emma Colbatch,
Yes.
here on behalf of the appellant father in Re J. Sitting next to me, my learned friend, Mr. Momtaz of His Majesty's Council, and behind him, his juniors, Miss Gatland and Miss Hughes, appear on behalf of the appellant in Re M.
Yes.
Then we have, moving down the row, Miss Clements of His Majesty's Council and her learned junior, Mr. Lang,
Yes.
who represent both the Secretary of State for the Ministry of Justice and the Registrar General for England
Yes.
and Wales. And then at the end of the row is Mr. Bow of His Majesty's Council with his learned junior, Mr Wilson, and they
Yes.
represent the respondent in Re J.
Yes.
My Lord, we intend to start with our oral submissions, followed by the appellant in Re M, followed by the respondent in Re J. The reason we have sought to apply that running order is so that the issues with which my lords and my lady are concerned can be linked thematically, and we hope that that has the advantage of having some assistance to the bench.
Yes. Thank you.
My Lord, before we go into any more administrative matters, if I may first introduce each of the appeals in the briefest possible way. The case of Re J, in which we appear on behalf of the appellant, involves a man known as KL. He and the child's mother, known as BA, believed that KL was J's father. KL was revealed by DNA testing not to be J's genetic father some years later, and in the intervening years, KL had parented J and acted as her father. In that appeal, there are abduction proceedings in the court below and Children Act proceedings in relation to J, and it was in the abduction proceedings that Deborah Powell, His Majesty's counsel, sitting as a Deputy High Court judge, heard legal argument only on the issue of whether KL ever held parental responsibility for J and determined that he had not. In Re M, the child in that case was conceived by donor sperm and artificial insemination, informal artificial insemination. The appellant in that case was intended to be the child's father by both parties and was named on the birth certificate despite not having a genetic link to that child. The appellant presented himself as the child's father, but in care proceedings, Her Honour Judge Tucker determined, having regard to the decision of Deborah Powell of His Majesty's counsel in Re J, but also advancing her own reasons, that the appellant had never held parental responsibility for that child. In Re P, a child known as A has two putative fathers, known as F1 and F2, who are identical twins. Genetic testing has taken place, but thus far has not been able to identify scientifically which of the two putative fathers are the child's biological father, but one of them, F1, is named on the child's birth certificate as her father. The judge at first instance, Her Honour Judge Reardon, held that the putative fathers are equally likely to be A's father. She did not make any declaration of parentage, and F1 remains named as A's father on her birth certificate.
Just in relation to P, and plainly we'll get to the case of P with counsel in the courtroom on another stage of the hearing, but a skeleton argument has been submitted, I think, today, so we've only seen it today, which indicates that the previous understanding, which was that more sophisticated DNA testing
Yes.
would cost something in the region of £90,000, might now be available at a more reasonable level of £14,000. So it does
Yes.
occur to us that the parties in REP need to consider that position
Yes.
and to consider funding options. Obviously, funding options might be available amongst the parties, but it might be at that level an expenditure on the legal aid certificate
Yes.
of the guardian, in which case the matter wouldn't necessarily proceed in this court and might benefit from going back to the lower court
Yes.
to admit further evidence. But I float that, not for anyone who's currently in this room to react to it now, but just so that those who are in REP can understand that that's an option that's
Yes.
occurred to us on receipt of that information.
Yes. Well, I know that will have been heard. I won't touch on that point.
Well, we hope that's been heard.
If it hasn't, we'll relay it.
Can I say, I should have said that the case is being relayed on live stream. Everyone has bent over backwards to avoid saying the names of the individuals involved, the children or the adults, and I'm fairly confident that we'll carry on as you have, Ms. Briggs, in using initials. If inadvertently some information comes out, I've got the ability to stop the live stream. But if any information does come out that might identify the individuals, nothing is to be published or reported giving that information. The identity of the individuals is to remain confidential, and there's to be no reporting of any of that sort of material.
So, my lord, all three appeals deal with the acquisition of parental responsibility by unmarried fathers under Section 4 of the Children Act 1989 and with declarations of parentage made under Section 55A of the Family Law Act 1986. And the appeals have been joined and are heard in this way because they raise important matters of public interest, which were set out as an annex to this court's order of the 23rd of October 2025 and can be seen in the core bundle at page 17, headed Legal and Common Issues. We are grateful to the court for setting out those issues in that way in advance of this hearing. We could not have done it better ourselves.
Well, I must apologise that you had to wait so long for me to apply my mind to it. I hope ultimately, despite the fact it necessitated some of you recrafting your skeleton arguments or the order of them, but I hope it ultimately was useful.
It was better that we know in advance, my lady, and so it was most helpful to all of us. And of course, given the importance of these appeals, there have been a number of inquiries to see the papers and 4 applications to intervene, which have been granted by this court. The interveners in all 3 appeals are the Secretary of State for the Ministry of Justice, the Registrar General for England and Wales, Reunite, and the Association of Lawyers for Children.
Yes.
The 7 questions have been addressed in the written skeleton arguments, which my lords and my lady have read, and there is a running order before the court to which I've already alluded. There may need to be some shifts in that running order given the timings of this hearing, and it would be helpful to know whether my lords and my lady might be inclined to extend their usual sitting hours so that we can then look back at the running order and see how we might divide speaking times as between the advocates.
So plainly today, as I said, we've got to rise at 4.
Yes.
So tomorrow we're due to start at 10 past 10. I don't know why 10 past 10 was. Have I got the wrong
I
running
may be
order?
able to answer that question, my lord. We had submitted a running order on the 17th of November, which was before there had been a change in the days of the listing. So it's of some vintage. And on that basis, we had requested an earlier start time of 10 past 10. So if you would be inclined still to sit at 10 past 10 or indeed at any time earlier than 10:30,
We can start
that
at
would be
10.
an
We can
assistance.
start at 10 tomorrow. Morning, I thought. Shall I got the wrong running
I
order?
don't know. I've got one that's got highlighted draft running order, and that shows us tomorrow starting at 10:30 with Mr. Norton.
No,
Is that
I'm
right?
It may not.
Carl Rowley, King's Counsel at 10 past 10 tomorrow.
At the best estimate, there have been more than 10 of these running orders, possibly more.
Well,
But I
logically
think
it will be Mr. Norton because we won't, on the current running order, particularly if we carry on talking about the running order, we won't have got to Mr. Norton.
well, why don't we say this, my lord? If you're prepared to sit at 10 o'clock, we will take the running order away at the end of the day and we will
Yes.
adjust it in such a way as can be managed.
And it's helpful because it manages everyone's expectation, but it's sure as eggs is eggs. It won't stick the thing. Some people
Yes.
would take longer or shorter, and it depends on any interventions from the court. What's important is the sequence,
Yes.
which you've carefully set out, and I don't think we've got any difficulty with. And we'll start at the beginning with you and carry on. So tomorrow at 10 o'clock start,
Yes.
usual lunch, and then presumably we can carry on to 4:30 tomorrow.
Very good. Well, then we'll take that
Then
away
we'll take
and
stock.
we'll work out and make sure that we can all have the time that we require.
Good.
Subject to any interventions. Turning then to the papers, you have the core bundle comprising 418 pages in which the skeleton arguments are all filed, the notice of appeal and so forth. There is an extensive authorities bundle. We are most grateful in particular to the solicitors who represent the appellant in Re-M, who overtook the role of lead solicitor in this case because we act pro bono as do our instructing solicitors. And it was Nicole Burge, the solicitor at HRS Solicitors, who prepared the electronic version of the extensive authorities bundle that is before my lords and my lady, with considerable assistance from second junior, the appellant in Re-M, Miss Hughes, and assistance from the third junior for the child in Re-P, Miss Sylvie Armstrong, who produced all of the hard copy bundles that are before the court today.
Right, well, we're very grateful to everyone for that endeavour.
Yes. There is in addition a slim white volume which contains the list of contacts. It also contains an excerpt from Hansard to which I will seek to refer my lords and my lady in oral argument. The reason that doesn't appear in the large authorities bundle is because there have been no fewer than 3 attempts to produce that document in a way that is legible.
The Lord Chancellor and Viscount Oswald.
Yes, and I can see, my lord, that you have it with the sticky tags attached to it.
Hang on.
I've got someone's handwritten sticky on a time present and time past.
Yes,
Yes.
and so I'll come to that
Yes, no.
document now.
That's separate.
That's separate. That's a document that the appellant in Re M seeks permission to rely upon. And my lords and my lady, I propose that that application be dealt with at the start of submissions for the appellant in Re M. It's not going to touch on anything that I have to say to the court today.
And I've now found the running order that my lady seems to have. So, there we are. Good.
Well, my lord, if we may then happily and with some relief put administrative matters to one side.
Good.
And if I may embark on my oral submissions for
Yes,
the
please
appellant
do.
in Re J. My lords and my lady, we intend to deal with legal and common issues 1 to 4, which I won't recite in full. Those can be seen in the at page 17 of the core bundle. And you have our written skeleton argument, which is at page 65 of the bundle. We don't intend to duplicate any of that. What we intend to do in our oral submissions is to cover the following points. First, how we say the scheme at section 4 operates and why, as a matter of statutory interpretation, statutory construction, the court is entitled to take that approach. Second, the operation of parental responsibility for married fathers and its impact on parental responsibility for unmarried fathers. Third, the duty to interpret the legislation in such a way as to protect the child's family life. And fourth, possibilities for ameliorating the harm that we say would be caused if the court was to follow the interpretation espoused by the respondents and the interveners, which here I use as a shorthand for those who disagree with our interpretation. Our client's position in a nutshell is this. 1, when a birth is registered, both the mother and the person stating himself to be the father make solemn declarations that the man so registered is the child's father. Second, those 2 declarations of parentage made before the registrar were intended by Parliament to be sufficient to evidence fatherhood for the purpose of acquiring parental responsibility. It being a matter for Parliament to decide how that parentage is to be evidenced at the point of acquiring parental responsibility. Third, Parliament intended parental responsibility to spring from the point of registration of a person as a child's father. My lords and my ladies, we say that the timing of this is very important. It is important for there to be certainty at the point that early on in the child's life as to who holds and who does not hold parental responsibility. Fourth, in not requiring DNA testing, as was readily available in 2002, Parliament intended that parental responsibility be acquired by someone not scientifically proven to be the child's father, biologically speaking. Fifth, Parliament intended that parental responsibility, established on the joint intention of parents at the child's registration of birth, be shielded from summary change. And it is section 4(2)(a) of the Children Act that provides that shield. Sixth, parental responsibility conferred under section 4 therefore survives a declaration of non-parentage made under section 55(a) of the Family Law Act 1986. parental responsibility also survives re-registration on the birth certificate, which, as we see from the skeleton arguments put before the court by the General Registrar, is a
And
separate
what was that?
administrative.
So it also survives re-registration.
Yes. It survives until such time as the court makes an order ceasing it or otherwise dealing with it. Which was our 7th point on our client's position in a nutshell. Our client's position on declarations of parentage is that he entirely endorses the idea that children should know their biological fathers. That was the position that he took in the proceedings below. He agreed to a declaration of non-parentage. He agrees to Jane knowing that he is not her biological father, but he feels that he should remain her father as a natural social father. And as you will see from the documents before you, that is a position that is supported by Jay's biological father. All of that said, we agree with the statement made by Her Honour Judge Case in a local authority and SB at paragraph 68. She says, of section 4, it is a complete scheme for the gaining and discharging of parental responsibility when acquired by one of 3 methods referred to within section 4.1, including where the parental responsibility was gained on a false premise. Why is that? Well, we say that parental responsibility is a creature of the Children Act 1989. It was brought into being by the Children Act 1989 and is governed by the Children Act 1989. It is a status that is welfare-based with a welfare purpose. Distinct from biological parentage and biological fact, it is a living toolkit containing all the things required for day-to-day parenting and the making of and consulting about important decisions. It can also be, as my Lord the President said in Re A in 2023, of flexible weight or standing. Some fathers have it, some parents have it, but do not use it. They may be absent from the child's life. Some use it with great frequency, weekly or daily. But one needs that toolkit to be a parent. The respondents seek to link a later declaration of parentage under section 55A with an automatic and retrospective effect on parental responsibility in reality. And we say that is wrong. Coming back to the idea of the timing being important, I said we need to know who has parental responsibility from an early point. It is used more frequently in the early years of a child's life, and certainty at that point is important. While the appeals before you involve cases in which DNA testing has been carried out, the doubt is known. In 2 of the 3 cases, the biological link or lack thereof is known. The vast majority of people do not have DNA testing at the start of the child's life. So whereas the respondents put their case as an argument for legal certainty, in fact it throws into uncertainty, we say, with certainty only being achieved, potentially, at the point of declaration of parentage. So we argue that that renders uncertain the status of PR for the vast majority of unmarried fathers who have neither DNA testing nor declarations of parentage. We say that viewing the scheme as a complete scheme in this way is consistent with the social policy aims of the amendment to section 4. In saying this, we rely on what was said, albeit by a different Secretary of State for the Ministry of Justice, in argument before my Lord in Re A in 2023. In the argument, and this is found at page 1791, in Authorities Bundle 7, which has a yellow spine,
Authorities 17.
1791. My lady, can I check that that is numbered bundle 7?
Bundle 5 of 8.
Very well, thank you.
It works on the, this is in the middle of Re-A.
It is. And its argument in the second paragraph, where I hope you find that paragraph starts, second, the introduction of the ability for an unmarried father to acquire parental responsibility. Very good. So the aims set out there are the acquisition of parental responsibility by unmarried fathers. Again, important to hold in mind that at the point where we're thinking about parental responsibility being acquired, most couples do not obtain parental DNA testing. And then partway through that paragraph, encouraging and promoting parental responsibility by consent and to minimise dispute about acquisition.
This is in argument.
It is.
Is it accepted in the judgment?
It's not referred to in the judgment, but we say that supports what our position, which is that there is a social policy aim, a legitimate aim, in ensuring that there can be no argument about who holds parental responsibility early in a child's life. And we say that that is carried out through the wording of section 4.1, in which the way in which, if you take the interpretation that we espouse, which is that parental responsibility is acquired at the point of registration of a man as a child's father, that provides certainty as to who holds parental responsibility.
But this passage concerns with the development of the Children Act. When the Children Act was first enacted, it wasn't possible for unmarried fathers to gain parental responsibility by being named in the birth certificate. This was a policy development to widen the pool of unmarried fathers who would, by the operation of the Act, get parental responsibility. But this passage that you've taken us to is all about unmarried fathers. So you've got to be a father to get the benefit of the policy.
And we
Now,
say
I'm not sure that helps us with the thing, the question at the core of this case, which is your client a father for the purposes of section 4?
Yes. So, my lord, we say that at the point at which the birth certificate was signed, at the point at which he was named as the father on the birth certificate, he and the child's mother had attended and declared him to be the father. And that was the evidence, we say, that Parliament intended be sufficient for parental responsibility to be conferred at the point of birth being registered.
It's sufficient for that. Then subsequently there's an issue, and more detailed and reliable evidence, the DNA testing, becomes available, and the court's invited to make a declaration, in this case, of non-parentage. And
Yes.
so the evidence then is of a different order.
Yes. And we say that it's section 4.2 that tells us that when the evidence is in a different order, parental responsibility can only cease to be or be terminated or be altered by order of the court. And there is a real benefit to that for children, because it means that once parental responsibility is held, it persists all the way through until the court can deal with it on a welfare basis. Whereas the difficulties that arise if parental responsibility was never held, and that has retrospective effect, is significant, because at that stage the difficulty arises as soon as anybody raises a doubt about parentage.
And so maybe the principal difference between you and those who take a different view is that the different view is that two conditions have to be met
Yes.
for parental responsibility to be triggered, your word, by section 4.
Yes.
One is registration on the birth certificate, but the other is that he's got to be the father
Yes.
in law,
Yes.
the legal father.
Yes.
And if the person turns out not to be the legal father, then the parental responsibility has never arisen,
Yes.
even though that circumstance may not be understood or known until some years later.
Yes. Well, I'll turn, if I may, in due course, to the difficulty under the Hague Conventions, which do present a significant difficulty, we would say. I think it is agreed would present a significant difficulty. But just one caveat in respect of the position on can a non-genetic father ever acquire parental responsibility. under section 4, it is pointed out on behalf of the Secretary of State for the Ministry of Justice that where an order is made for parental responsibility in respect of an unmarried man, under section 4(1)(c), even if that order is made on the misunderstanding that the father was the genetic parent, that order is valid and enforceable until such time as it is discharged. That is in the skeleton argument filed on behalf of the Secretary of State for the Ministry of Justice at page 329, Bates number PDF 349, paragraph 46. So, on any view, to some extent, a non-genetic father may acquire parental responsibility under Section 4 of the Children Act 1989. And in those circumstances, if the court makes that order, as often the court does, if there's no need for DNA testing because both of the parents present as agreeing that the father is the genetic parent, even on a misunderstanding, that order can be made and remains valid and enforceable until such time as it is later discharged. And turning to the potential and significant, not our words, the words of the Secretary of State for the Ministry of Justice, problems with what we would say is the summary loss of parental responsibility, and that is the abduction gap and the jurisdiction gap. We say that those issues inhibit the protection of children's rights and of obligations to protect children's rights under the European Convention of Human Rights and the Hague Conventions. If I can invite my lord and my ladies to turn to page 242, which I hope is in the first bundle of the authorities bundle, and you should there, 242, my lord.
Thanks so much.
You should see the Convention on Civil Aspects of International Child Abduction, brought into the law of this country by the Children and Abduction Act 1985. The preamble to the convention tells us that the convention is convinced that the interests of the children are of paramount importance in matters relating to their custody, and desiring to protect children internationally from the harmful effects of their wrongful removal or retention, and to establish procedures to ensure their prompt return to their state of habitual residence. And my lord, I'm touching now on issues that are also raised in the Reunite skeleton argument, but if I may briefly take the court through the way in which the difficulties arise. Article 3 defines removal or retention of a child as wrongful where it is in breach of rights of custody attributed to a person, institution or other body, jointly or alone, under the law of the state in which the child was habitually resident, immediately before the removal or retention. And at the time of the removal or retention, those rights were actually exercised jointly or alone. Parental responsibility is often the primary means by which rights of custody are established in cases of abduction. The significant difficulty arises in the idea that a person who is not a genetic parent never had parental responsibility with retrospective effect. All it would take would be for a parent to remove a child to a country, once there, to say, the father is not actually the genetic father. He may have thought he was, but he is not. He has no parental responsibility. What right does this court have, I speak to whatever court it is that the proceedings are in, to tell me to come back to this jurisdiction with this child?
What if, sorry,
Yes, my lord.
to ask very basic questions, but what if, despite not having parental responsibility, the child had been in the care either solely or jointly of the person who objects to the abduction?
If the child was sorry, my lord.
No, that was my question.
Yes.
What's the position?
So the Hague Convention distinguishes between rights of custody and rights of access. So it would be, I may need to turn my back to my learned junior on the position of a child who was living, say, half of the time with a parent who had no parental responsibility. But certainly for many parents, I take for as an example my client, who was having regular access or contact with his child, didn't have parental responsibility. It's the parental responsibility which fans the rights of custody, and the spending time with, which is the exercise of those rights of custody. If he was spending time with the child and had no parental responsibility, then there would be a significant difficulty in him showing that he had those rights of custody.
Is there any authority about that?
There is, my lady. I regret to say it's not in the bundle of legal and common issues, but I can try to find one for my lady. It may be that we bring it at a later stage, but we will deal with that. But it is for that reason that Reunite puts its case in the way that it does. It's for that reason that Reunite has sought to intervene, as I understand it. But of course you will have read those documents. It's the unilateral act and the fact that we have real difficulty if somebody says, let me put it this way, the point in time at which the rights of custody need to have been established and exercised is, in this document, immediately before or at the point of removal. If at a point following removal, those rights of custody are in dispute, or indeed were never had, with retrospective effect, then that potentially defeats the aims of the convention, which is to protect the child from wrongful abduction. Those rights cannot be reconstructed ex post facto, because the removal has happened and the point in time specified in the Hague Convention has passed. But also, a significant difficulty for the child concerned and the father in that position is the father was, before that point in time, taking a phrase from our skeleton argument, walking around with illusory parental responsibility. He did not know that he had the need to protect the relationship with his child because he was led to believe that he was the child's father and that the declarations made at the point of parental responsibility being acquired were valid, and therefore he had parental responsibility.
And so I think you would say, and I think this may be partly an answer to my Lord's question, if an individual in that position had known that he wasn't the father and therefore didn't have parental responsibility, if the Secretary of State's right, but he had a very close relationship with the child, spending lots of time with him, he would have secured his position by applying to the court for a Section 8 order,
Yes.
thereby getting the equivalent of a custody order
Yes.
and achieving parental responsibility.
Yes.
But because he is lulled into a sense of
Precisely.
false security by the birth certificate,
Yes.
hasn't done that,
Yes.
abduction happens, he goes to the court and they say, sorry, you're not the father, you
Yes.
haven't got parental responsibility, you've never had it, there's nothing you can do under the Hague Convention.
My lord, yes. And the same problem arises with jurisdiction under the Hague Convention 1996. Jurisdiction there is founded on habitual residence, but there are provisions within the Hague Convention 1996 about wrongful retention or removal, which have the same difficulty. I can go into that in more detail if your lordship would require me to, but it's essentially the same
It's
point.
the same point. Yeah.
And it's on a different document which is subsequent to.
What about those rare cases that are pursued under the inherent jurisdiction because they can't go under Hague, where they go by way of British citizenship?
Those tend to be cases where the country in question is not a signatory to the Hague Convention.
There's something that says it should be. It's because the Hague Convention is not available. But the child
Yes.
in question is a British citizen who's been wrongfully removed from his country.
Yes.
Is there any reason that I'm not saying it would be an attractive route? I'm
No.
just trying to see what different routes may or may not be available. But
Yes,
it
my
seems to me
lady,
that
and
might
that's-
potentially be a route.
It
It's an
might
attractive route, not
No.
one you'd wish to use. But what you're talking about isn't something common in any event.
Well, the use of the inherent jurisdiction to plug a gap in the Hague Convention one would imagine, and these cases are usually argued very strongly on both sides, I no doubt would be argued very strongly to the contrary,
No
on
doubt.
behalf of the mother who has left the jurisdiction and who would then be in a position under the interpretation espoused by the respondents to say, none of this matters. He was never he never had parental responsibility. He does not have rights of custody. And that's almost a more fundamental point, we would say, in relation to jurisdiction in international cases, where there needs to be, as far as is possible, a way in which different jurisdictions can understand one another as to where that jurisdiction lies. So in theory, my lady, it is a possibility, but it's certainly not something where we found much in the way of authority that would support that, and it's certainly something where one would expect there to be strong attack. But where there is a statutory scheme and a convention underlying it, which the person who we are talking about, the unmarried father, does not fall within, then there would be an argument to say, well, we should not be using the common law or the inherent jurisdiction to, in essence, subvert that system. Dealing, before I move on, with the arguments made by the Secretary of State on behalf of the Ministry of Justice, that these gaps, the abduction gap, the jurisdiction gap, should not alter the statutory interpretation. It's said, it's put at paragraph 51(1) of the Ministry of Justice's skeleton arguments, that the obligations under the Hague Convention 1980 do not stretch to those fathers who mistakenly claim to be a father. In response to that, my lords and my lady, we would say that this is an instrument, this is aimed at the protection of children. It should stretch, it should accord to children whose fathers, we say, validly acquired parental responsibility at the start of that child's life and who are exercising that parental responsibility. And the court should adopt the interpretation that best extends that protection to children, because that is the aim of the Hague Convention 1980. And we make the same point in respect to the Hague Convention 1996 and jurisdiction. My lord, going to the question of definition of father, the arguments have been made that the definition of father is certain, it is clear, it provides an obvious answer to anybody who wants to understand who can acquire parental responsibility under Section 4 of the Act. My lords, my lady, I know that Mr. Momtaz of His Majesty's Counsel is going to touch on this in a little more detail on behalf of the appellant in Re M, but all of the respondents say that it's a very simple, clear definition, but they all express it in different terms and over many pieces of paper. It is not as straightforward as might first appear. I would like now to turn to the excerpt from Hansard on which we rely for 2 points, one of which is the ambiguous definition of father. It's been said that the Pepper and Hart test is not met. And if I might address those points, then address the position in respect to the material that's before you, so that my lords and my lady can make a determination on the preliminary issue and deal with the arguments that we make in respect to the material. So the test in Pepper and Hart is settled in 3 parts. Firstly, the legislative provision is ambiguous. Second, the material includes a statement made by the minister. And third, the statement is clear and unequivocal on the point of interpretation. Now, the documents which the Hansard excerpt that we have produced, we rely on in the following way. First, whether a non-genetic married father acquires parental responsibility under Section 2(1) of the Act. And second, whether the meaning of father is static or changes throughout the Act.
So one was whether a non-genetic married father
Yes,
acquires PR.
yes.
Yep. And the second was
Whether the meaning of father is ambiguous or indeed changes through the statute.
thank you. Thank you.
My lord, we say that the legislative provision is ambiguous. There have been cases in the High Court in which the position of an unmarried father relative to parental responsibility at the point where biological link has been determined not to be present has been the subject of argument before the High Court and is the subject of some ambiguity before this court, we say. And secondly, the definition of father is something that is the subject of argument before my lords and my lady in this hearing. So for that reason, we say the first part of the test is met. The second part of the test we say is met because the material does include a statement made by a minister, the Lord Chancellor.
So you mentioned that it's rather circular to say we're disputing the definition of father and therefore the definition is ambiguous.
Yes.
So I understand what you said there, but you referred to High Court authority, which
Yes.
is said to be inconsistent, presumably. You're saying it's ambiguous.
Yes. So
So are you going to take us to those cases?
I can, my lord, yes. So the authority of Re R, which is a decision of Mr. Justice Jackson, as he then was. And that is in the supplemental bundle of authorities. Mr. Justice Jackson decides in that case.
Hang on, the supplemental bundle.
It is.
Which is that?
I believe it is a blue binder. It's at page
Blue.
61.
I haven't
It's
got it.
there, it's there.
Oh, there on. I've smothered it.
Here are, so it's in page 53 of the
Yes, and the part to which I would like to refer is page 61. Paragraph 39.
I'm so sorry, which paragraph?
39.
Thank you.
You'd like us to read that?
No, once you've found it, my lord, I can take you to the part that we
Yep,
say
but
reveals the
all-
ambiguity.
We're all here.
So, Mr. Justice Jackson, as he then was, determines that once the lack of genetic link is revealed, parental responsibility for a married father falls away. But when turning to the welfare analysis, he is ambiguous as to whether or not that parental responsibility was ever had.
Where are we?
Yeah, I'm
So
trying
we
to-
are, he is not George's biological father, so in the middle of that paragraph. And I do not consider it is in George's true interests to invest or reinvest Mr. R with parental responsibility.
That's not presuming he's had it throughout. That's leaving that open.
Yes, so it's ambiguous as to whether it's with
Well,
retrospect.
you didn't decide it.
No,
Why
it
is it
wasn't, it
ambiguous?
wasn't the issue in the case.
So, very well,
It's a declaration of parentage case.
yes. With a decision as to the impact on parental responsibility. And whether or not it is retrospective, therefore whether the married father ever acquired parental responsibility at the point of birth.
But it's the definition of father that you'll say is ambiguous.
Well, there are 2 points here. First is the acquisition of parental responsibility or otherwise by a married father once it's discovered he doesn't have a genetic link. And the second is the interpretation of father. So this deals,
This observation by Mr. Justice Jackson is about whether the individual had parental responsibility, not whether he was the father or not.
yes, so that's one of the areas in which we say that there is some ambiguity. you're quite right, my lord, it doesn't deal with, it's not on the point
No.
of the definition of father.
So it may be that I'm behind the pace, but
No.
that you're wanting to take us to Hansard because there's ambiguity about the definition of father.
Yes, well, if I deal with that point then, rather than
That's
the
what I thought
married
we were
parent
going to.
Very well. My apologies for moving on to a separate track. The definition of father, we say, is of some ambiguity because there is the proposition that is espoused by ourselves, and I think by the appellant in Re M, is that we say the definition of father is relatively static. However, in the excerpt from the House of Lords, those in the debate refer to the fact that the definition of father appears in some cases to be genetic and in some cases to be legal.
Sorry, take you back one track. I think we asked you whether or not there was, you'd said that there had been some ambiguity about the definition of father in High
Yes.
Court cases. And we asked you, we thought you would take us to High Court cases which identified ambiguity in the definition of father. And point us to our, that's about PR,
Yes,
not the father in High Court cases which make a finding that there is ambiguity as to the definition of father, or find from a legal point of view that psychological is enough for the purposes of registration.
there is no High Court case that says that psychological father is enough for the purpose of registration. If I may, since your ladyship has raised this point, make it absolutely clear at this point that we do not propose a change to the legal definition of father. We say that the scheme at section 4 coexists with that definition. That what happens when
What do you say the definition of father is then?
we say that the definition of father may be legal or may be genetic, we say that our client doesn't fit, once he's had his DNA testing, the definition of legal father, but he acquired parental responsibility at the point when he was registered as the child's father, because that is the evidential test that Parliament has put into place.
So going back to our common and legal issues,
Yes,
number one, does father have to be a genetic parent to acquire responsibility under section 2? The answer is yes, he does, but you say section 4 protects him.
we say the answer is, my apologies, my lady, we say the answer is that he may acquire parental responsibility without being the genetic parent, because at the point when one has to assess whether parental responsibility has been acquired, there are 2 declarations from the mother and the father that he is in fact the child's parent. Those declarations may be made mistakenly
Or dishonestly.
or dishonestly. Dishonestly on pain of criminal prosecution. But once those declarations are made at the point of registration, that it is from that act that parental responsibility springs.
The Registration Act.
From the act of registration.
No, with the small a, the
Yes.
process of registration.
Yes,
Yeah,
I'm grateful. In the process of registration, parental responsibility springs, because that is the evidence that is good enough to evidence fatherhood. That's the scheme we say that Parliament has put into place. And we say that that is logical because there is no requirement for DNA scientific evidence. Parliament could have put that in to the statute, but did not. And so the parents attend with their declarations, and parental responsibility is created for the benefit of the child and persists until such time as the court can take a look at the difficulties and see whether, firstly, is he a genetic parent or not, and secondly, how do we protect that relationship rather than it being dismissed summarily and with reference to a past fact, rather than with reference to what is happening for the child in her relationships at that point in time. So, my lady, we say that this is a scheme that coexists with those definitions.
But in terms of the legal definition of father, you accept that is that the genetic father is the father as a matter of law.
For an unmarried father.
For an unmarried father,
Yes.
yes. And for a married father.
Well, for a married father, there
A
is,
father is the genetic parent.
for a married father,
Mother
there
gives
is-
birth. The father, as I think Mrs. Justice Bracewell said, the father is the person whose sperm fertilised the egg, created the embryo that became the child.
subject to
genetic father.
the presumption of legitimacy. So in
No, I think we need to be plain about that. That there's presumptions, the parental responsibility, but in terms of when the term father is used as a matter of law, that means the genetic father. Do you accept that?
in both married and unmarried fathers.
Yes, father.
Well, my lord, until again we get to the point of what happens before DNA, before scientific testing. And so in respect of married fathers, until such time as genetic testing reveals the truth or otherwise,
And
of the
that's a
genetic
matter of evidence.
there is a presumption.
That's a matter of evidence, how you prove it. But I'm just keen to understand whether you differ from the approach taken by the Secretary of State and the respondents, that in law, father means genetic father.
The legal presumption of fatherhood does still apply
That's
until such point
not
as
presumption. Nobody other than the genetic father can be regarded as the father of a child as a matter of law. That's what is being put forward.
yes. Well, you'll see that in our written argument we make reference to who is presumed to be the father until such point as the
No,
evidence clarifies.
it's a straightforward question, Ms. Briggs.
Yes.
Do you accept as a matter of law that the father of a child is that child's genetic father?
Well, Lord, I think our position in respect to the unmarried father is yes, we do. In respect of a married father, if given your lordship's indication as to the presumption being one of evidence rather than one of law, then that must be the case.
Well, just because I say it doesn't mean it's right. Although if you've been in this job long enough, you become to believe that. But a married father, the presumption is that that person is the father, but it's a presumption and it can be displaced presumably by DNA testing.
Yes.
Thank
And we come back to the question of how one achieves clarity before DNA testing is available, before declarations of parentage have been made.
You've rightly taken us to the fact of the declarations and so on,
Yes.
and the fact before you've got DNA testing. So at that point, I think you say what we think at that point is that the father is the biological genetic father,
Yes.
and that therefore ties in with the definition of father.
Yes.
I perhaps misunderstood, but I thought your focus was that being the case, when that is upturned by
Yes.
a DNA test, what happens about parental responsibility,
Yes. It is.
which had gone with being the father which everyone believed him to be.
Yes.
And the question then is, it turns out that he's not the biological father. Did he ever have parental responsibility? Or did he have parental responsibility because everyone thought he was the father,
Yes.
and that continues until an order's made discharging it?
Yes.
I thought that was the focus.
Yes. So, my lady, if I return to that focus, these schemes for married and unmarried fathers do operate in different ways. As we say at paragraph 27 of our skeleton argument, when it comes to unmarried fathers, in each of the three situations, 4A, 4B and 4C, there has been evidence specifically directed at whether or not the man in question is the child's father. So I should say that with the registration, the parents are making the binding declarations as set out in the Births and Deaths Registration Act. With a parental responsibility agreement, the parental responsibility agreement contains a declaration which must be signed by both of the parents that the father is the child's father. So at that point in time, at the creation of parental responsibility, those declarations have been made. And in a way that is, again, differs from the scheme under section 2.1. Section 4.2a, we say, does two things. It provides for the possibility of revocation of the parental responsibility that we say was acquired through those processes at sections 4.1a, b and c. And it also says that parental responsibility persists until that revocation takes place. So it provides a sword, the cutting away of parental responsibility, and a shield. Once the parental responsibility is there, it persists. Whereas section 2 is silent, it offers no revocation and no shield.
But the whole section, section 4, I'm looking at page 96 of the
Yes.
authorities bundle, is headed acquisition of parental responsibility by father. And then we all know section 1 where a child's father and mother are not married. It's all about the father. So irrespective of whether it's a birth certificate or a parental responsibility agreement, if the person is not the father, it can't apply to him, can it?
We say it can on the evidence that Parliament has said suffices for parental responsibility to be conferred at those points.
That assumes what you're trying to prove, doesn't it? Because you accept that, as I understand it, that normally, in a legal context, when you refer to the father, you're referring to the biological father. So you have to establish that there's something in this statute which means that father doesn't bear its normal meaning, but is wider and includes people who are not the genetic father. And at the moment, I don't understand how section 4.2a helps you on that at all. All that says is, if you're right on the first half, then you can pray in a 4.2a. But isn't your challenge, not going to call it anything more than that, your challenge to demonstrate the reasons why, in this context, father means something different? At the moment, I'm not sure that from where I'm sitting, a slightly non-specialist seat, I'm not sure that your answers to my lord and my lady are addressing that point.
Yes. We say section 4.1a, b and c set out a means by which the evidential threshold for father is met at the point when parental responsibility is acquired.
My point is, forgive me for interrupting you, it does that one can accept that this is a scheme. That doesn't tell you who is being the subject of the scheme, whether it's biological father or the non-biological father.
So as is accepted by Home Judge case in Re C, whereas the intention of Parliament was to confer parental responsibility on married biological fathers, the scheme by which that was achieved was a scheme of providing for the father to be identified before scientific evidence has been produced.
You're getting closer, but you still haven't demonstrated what the purpose of why you say the purpose of the statute is to assist non-biological fathers under section 4.
The reason why is because there was a policy aim to increase the number of unmarried fathers who would acquire parental responsibility. And yes, again, I'm using the phrase unmarried father, my lord. I can see you have picked that up. But in order to encourage fathers, unmarried fathers, to acquire parental responsibility, the scheme that was settled on was not a scheme of DNA testing. It was a scheme of joint declaration as to parentage. And that scheme contains a margin of error. And we say it was a margin of error that was known to Parliament. I know that that appears in the skeleton arguments of others. And that the margin of, when fraud or mistake is discovered, the means by which that is approached, the means by which that is tackled, is under section 4.2a and nowhere else. It is not the case, we say, and we say in fact that this is an interpretation that would potentially lead to protection for children being reduced, for parental responsibility to be pegged entirely on the question of legal parentage once the genetic testing has been carried out, provided that there has already been a declaration by both mother and father that the man in question is the child's father. If I may turn
Yeah.
now to obligations under the Human Rights Act.
I thought we were going to Hansard and you were laying the
Yes.
ground for your pepper and heart.
My lord, yes, I'll come back to
Application.
that point.
Yeah.
No, I'm assistant. So the definition of father, we say, is ambiguous in this statute and in others. In this section in Hansard, I'll take my lord to the parts about parents. Those are flagged with yellow tabs in the excerpt before my ladies and my lords.
But in order for us to be looking at Hansard or taking account of it, you've got to get through the hurdle, get over the hurdle of pepper and heart. And simply saying the definition of father is ambiguous, but accepting my question that the definition of father is the biological father, the genetic father, I certainly haven't seen anything that suggests that the definition is ambiguous.
And my lord, yes, you're quite right. Us having had that discussion means that we are rather past this point. So I shall move on.
Thank you.
Just tidying off that
Yes.
line. Having accepted the husband's invitation that genetic father purposes of registration, so far as section 4, acquisition of parental responsibility by father, do you similarly accept that the father for section 4, genetic father, I know what your suspicions are about parental responsibility and whether they had it mistakenly, they carry it and keep it and so on, but do you carry on that concession?
Well, we accept that the legislative aim was for a genetic father. But we do not accept that it must be the case that the genetic fatherhood is evidenced by DNA testing at the point of acquisition of parentage. So in respect of the answer to question 1, our answer is a genetic father may acquire parental responsibility under section 4.
Thank you.
As I've understood your submissions, you say that Parliament has not stipulated that before anyone can claim to be the father, there has to be a DNA test that proves that they are the father. That Parliament wanted to expand the pool of unmarried fathers who obtain parental responsibility in a readily accessible way,
Yes.
beyond parental responsibility agreements or court orders, and being named on the birth certificate is obviously what was chosen. And you say to a degree that's rough and ready. If you're not having DNA testing, you've got to rely on what people say. But if the couple come along and say that he is the father, and if he makes a declaration that he's the father, Parliament will go with that,
Yes.
accepting there's a margin of error
Yes.
on some occasions, either through people genuinely thinking that the individual is the father, then finding out not, or
Yes.
the fraud. But the purpose of the legislation is to simply have a readily accessible scheme
Yes.
for people to identify whether or not they have parental responsibility.
Yes.
And if you go through the scheme and you register the birth, then you get parental responsibility, whether or not actually you are the father. That's
Yes.
whereas those on the other side say, no, these are two separate conditions. It's all very well registering the birth, but if you're not the father, it doesn't work.
Yes.
You don't get parental responsibility.
Yes, and if I may say this, there is, however, on the part of the respondents, a concession that the world around us is entitled to rely on the birth certificate as to evidence who holds parental responsibility. So this is in the respondent to Jay's skeleton argument at paragraph 58. The world at large is entitled to treat the appellant's registration on the birth certificate as evidence that he is a parent and therefore has parental responsibility. So the precondition argument doesn't really solve the problem in reality of people who are not strictly eligible not acquiring parental responsibility, because the world at large relies upon those documents as evidence that the person has parental responsibility. The parents have both already agreed that that person has parental responsibility through the process of registration or the process of parental responsibility or through the court order. And so to all intents and purposes, that person holds and exercises de facto parental responsibility, or in our case, valid parental responsibility. And it is in the gap between the registration of the birth, where the father and the mother publicly identify the man as the father of the child, and a later discovery that the father may not be the genetic parent of the child, that family life arises. It is in that time that, in my client's example, he exercised his parental responsibility. He made decisions about his child that shaped the course of her life. He initiated court proceedings on the basis of that parental responsibility. He used the toolkit of parental responsibility only later to be told in a moment, with no welfare analysis, that that parental responsibility was no longer, and he had no capacity to make decisions or to protect, he would see it, his daughter, from poor decisions being made by the other parent. And this, my lords and my ladies, where we say your obligations under the the Human Rights Act come into play. Now we know, of course, that it has been said, and this is relying on Poplar Housing Association from 2002 in the Court of Appeal, that unless the legislation would otherwise be in breach of the Convention, Section 3 can be ignored. So courts should always first ascertain whether, absent Section 3, there would be any breach of the Convention. 2 years later in the House of Lords, in Gaydon and Godin Mendoza, and this in the authorities bundle at page 996. It should be, I hope, bundle 3. Yes, 996, my lord, working electronically.
You look at paragraph 25.
Yes, 25 to 30. So, paragraph 26, all legislation must be read and given an effect in a way which is compatible with Convention rights. It's over the page at paragraphs 28 and 29. Where Lord Nicol refers to a possible interpretation as being that Section 3 is confined to requiring courts to resolve ambiguities. And that paragraph 29 says that this interpretation would give the section a comparatively narrow scope and is not the view which has prevailed. The application, he says, of Section 3 does not depend upon the presence of ambiguity in the legislation being interpreted, even if, construed according to the ordinary principles of interpretation, the meaning of the legislation admits of no doubt. Section 3 may nonetheless require legislation to be given a different meaning. And my lady and my lords, we say that in that gap, where that family life has been generated, where the parental responsibility is being used, family life within the meaning of Singh develops, a relationship develops, and a specific part of that relationship is the decision-making toolkit and the parental responsibility that exists for the benefit of the child. And my lord and my lady, we say that this court has an obligation to protect that relationship generally and those particular aspects of that relationship, so that they do not fall away summarily upon a determination about a past fact, or indeed in the case of Re P, are not thrown into uncertainty when a past fact cannot be determined. Parental responsibility is a creature of welfare and needs to be determined with regard to those principles. And my lady and my lords, that is why we espouse the complete scheme interpretation and why we say that this court should adopt that interpretation when dealing with these provisions in the Act.
So there was a jump on the facts of the case. You say, and I accept that for the purposes of this argument, that your client has family life rights with respect to the child under Article 8. Article 8's engaged,
And vice versa. my lord.
and vice versa. They've got family life together. And I think you said that within that context, the parenting toolkit and parental responsibility develops.
Yes,
Is that-
it is exercised as a matter of fact.
Right.
So there may be times when
So in reality, he's taken the child along to nursery or the doctors or wherever and acted as if, because he thought he had, as if he'd got parental responsibility.
well, specifically in this case, it's a little more than that. It's the starting of proceedings to bring the child back to the jurisdiction when
Yes.
she was taken
So,
away.
yeah.
It may be things such as being consulted on important matters as to medical treatment. So points in time at which parental responsibility gives this person the consultation rights. Discussions about
Is
where
there a
the
danger of
family-
mixing two completely separate concepts? There's Article 8 rights to family life and,
Yes.
and how that should be protected, how the state shouldn't intervene as is proportionate to do so, etc. And establishing that as a matter of domestic law, a person does or doesn't have parental responsibility. Are you using Article 8 in some way to say, well, out of the oven comes parental responsibility because they've got family life and because that's the way they were acting? Because the attribution of parental responsibility surely must be a matter of domestic law.
Yes, no, my
Whether
lord.
that law is compatible with the convention is another matter, but whether he has parental responsibility must be determined only under the terms of domestic law. Is that right?
Well, we say that this is a reason why of the two interpretations you choose the one that we espouse rather than the other. We're not saying that the establishment of de facto parental responsibility means that he has acquired parental
Right, I'm
responsibility.
with you.
That's a-
So you're relying on Gaydon to say, well, if there is ambiguity as to whether he did or didn't get parental responsibility, we err on the side in your favour,
yes.
because that would be compatible with the family life rights that they'd established on the erroneous basis that he'd got it.
It's not, yes, but it's not simply the a nebulous family life argument. It is about the specific aspect of that relationship that parental responsibility brings. So the capacity to make those decisions, the capacity to be a good steward of the child's life, to help shape her life, particularly where there might be differences of opinion about something. So the child, in my submission, and this is established in other authorities on the papers, benefits from parental responsibility. She benefits from having two parents making decisions about her life. And where one of those decision makers disappears from the pool of decision makers, that specifically is something that needs to be protected, because the parents at the start of this child's life decided that there will be a two-parent decision-making structure.
Yeah,
Thank
okay.
you.
And can I ask another very basic question? How does section 3.5 fit into your interpretation?
So section 3.5 is for people who actually have the care of the child, and they may be able to do whatever is necessary while having the care of the child for the benefit of that child.
You've been talking about the creation of relations between, which means that he takes them to, take my lord's example, takes the child to school, makes decisions about where to go to school, medical treatment and all that sort of stuff. Isn't that also what 3.5 is talking about?
It's not, my lord. We cite a case in our skeleton argument in which the limits of section 3.5 were considered by the court in respect of grandparents, and it was grandparents asserting through section 3.5 from memory the right to say where a child lived, where a child resided, and it was held that actually Section 3.5 falls way short of that. It's not a general decision making, it's a,
That in mind.
not at all.
But
Just give
anyway,
us the
that's,
reference for that, please.
Yes, my lady. So it's paragraph 63 of our skeleton argument, page 83 of the core bundle. And there are two authorities there, M and Re-S. And it was the latter, Re-S, to which I referred, but Re-M also.
Sorry, what paragraph in the skeleton?
So it's paragraph 63 of our skeleton argument,
you.
my lord.
These are in the bundle, I presume.
Lady, I'm afraid not. It's uncontroversial points. They have not found their way into the bundle, but we can of course furnish my lady and my lords.
So, 3.5, to pick up my Lord's observation about it, but my understanding of it is that it's there so that if you've actually got the child in your care, you can get on with doing what's reasonable
Yes.
in terms of looking after the child without having to phone up someone with parental responsibility, say, is it all right if I put his blue trousers on today rather than the yellow ones, or whatever it might be. It's more, it's the practical working out
Yes.
of caring for a child and giving you some authority to do that. If there's an emergency, then you act under 3.5.
Yes.
But it's not a status that is akin to parental responsibility in any
Yes,
in
and
any
section
way.
2.9 I think is raised in one of the other skeleton arguments on behalf of the respondents, and the same applies to that. But to a lesser extent, that's more nannies and boarding schools. Moving on then
Sounds
to
like
the
another age, isn't it? Nannies and boarding schools.
moving on then to what can be done to reinstate the position. And my lord, I'll take this as quickly as I can, given the time.
Well, we're interrupting, and you've got the benefit and burden of going first, Miss Briggs, and so we're dealing with points that hopefully won't arise with some of the others.
My lord, yes. We align ourselves with Reunite, and you've seen what we said about the need for there to be interim orders to protect the position of these individuals who, if you are not with us, would lose parental responsibility immediately. If I can refer to paragraph 54 of our skeleton argument, which appears at page 80 of the core bundle, in which we go through the points of uncertainty that we say arise. And I'm going to go back to that to look at, is there a way in which we can ameliorate things for these people who might be in these points of uncertainty? I've already touched on the situation at section 54A where somebody is walking around with illusory parental responsibility. That is, there's no way of remedying that because that person does not know and in fact believes that their parental responsibility is present and protected. We say that it is. Where mere doubt is cast upon somebody's genetic parentage, if that was to have an immediate impact with retrospective effect on parental responsibility, then there are difficulties there because frequently it may be a doubt raised by the gestational parent, it may be a doubt raised by a third party. Court proceedings are not in train. If that is the case, then the person who seeks to re-establish that important relationship and those important parental tools needs to go to court, needs to gather the evidence to put the welfare decision before the judge and needs to get to that welfare decision in order for those things to be reinstated, and that may take a period, as we know very well, of many months to come to fruition. All the while, the child does not have that constant link to the father and has disappeared. At the point where a declaration of parentage is made, under the Family Law Act 1986, that statute does not fall within the definition of family proceedings within the Children Act 1989. So again, separate proceedings would have to be initiated to get to the point of reinstating parental responsibility.
On ground level, very often they're tied in with child arrangement audits the normal course would be, in one of these cases we had as well, didn't we? I mean, you have the application of the declaration of parentage within the overall context of a welfare.
Yes, I mean, that's a less strong point than when there are no court proceedings. I entirely acknowledge that. And one that you might resolve by saying at the point of declaration of parentage, well, subject to an undertaking that an application is going to be made, then we can deal with it and make an interim order. But of course, we are dealing with welfare matters, and there would need to be some evidence of welfare in order for the court to make that order. Unless, of course, the court was to, as a matter of principle, hold the ring by some interim order with a recording saying this will persist until such time as the welfare part can be heard. But of course there are times, and one of the appeals before my lords and my lady are before you, where a declaration of parentage cannot be made. DNA testing does not reveal the truth, or indeed if the court has used the section 55A5 welfare out to not make a declaration of parentage for welfare reasons. Again, another reason we say to uncouple section 55A from parental responsibility under the Children Act 1989. Why should there be any dispute over parental responsibility? Simply because there's a dispute as to the facts of parentage in the past. Some other areas where this is not easily done in terms of rectifying the position for a parent who finds himself bereft of parental responsibility and a child, where parents are living under the same roof, because in those circumstances section 12 parental responsibility ceases to apply when parents have lived together for more than 6 months, and when there are care proceedings, because the court frequently can't make section 8 orders in those proceedings. Our client, of course, finds himself in the happy procedural position of having a section 8 order, which means that parental responsibility, he hopes in due course, will be reinstated for him. But we say that if there is a movement to follow the interpretation that is espoused by the respondents in this case, it is of great importance for the court to, should it feel appropriate so to do, give guidance as to ensuring that children do not lose out from this proposal or from this interpretation. Indeed, it was His Honour Judge Meridifar, sitting as a High Court judge in Re C, who said it would be helpful for there to be a date from which parental responsibility ceases to be able to be relied upon, so without retrospective effect in his view. But in my submission, it is helpful for there to be some provision put around the child to ensure that that child can be protected and responsibility remains. Of course, my lords and my ladies, should you agree that parental responsibility springs from the processes in section 4(1)(a), (b) and (c), those difficulties do not arise and parental responsibility remains secure for the child until such time as the court can deal with the welfare issues properly. My lords, my lady, may I turn my back for a moment? Excuse me. Thank you. Is there any other matter on which
No,
I can
there isn't.
assist you?
Thank you very much, Ms. Briggs. Thank you indeed. Yes, Mr. Montaz.
Lords and my lady, I hesitate to ask you to look at another document given the size of the authorities bundle, but with your permission we do seek to rely on the speech given by Lord Reid in 2022, and that is titled Time Present and Time Past, Legal Development and Legal Tradition in the Common Law. And that goes to, in our submission, two key issues in this case. To what extent the common law principles can be regarded as certain and fixed, and how common law principles should be applied in the modern world. Lord,
So this is, just to get my eye, and I didn't look at this bundle before we came into court. This is at the back
it's
of
the
the
blue
quorum,
bundle.
quorum 11GC bundle.
Yes, and it's the back of that. I've handwritten a note on
In the
In this
In the supplemental
this
bundle,
one,
yes.
it's the one that my lord
yes.
pointed to with
Thank
the
you very
post-it
much.
sticker
Yep.
on it. So this is a lecture given by Lord Reid
Yes,
in February 2022.
Lord, yes.
So on what basis are we looking
Well, my Lord,
at this?
this really is to meet some of the arguments that are made on behalf of the Secretary of State in relation to common law principles, the extent to which common law principles can be regarded as certain and fixed. One of the submissions that we make to my Lord and my Lady is that this issue has not been dealt with, certainly at this level, in terms of the interaction or the relationship between parental responsibility, the acquisition of parental responsibility, and the meaning of father at common law. And it may be necessary for this court to review the authorities, and in particular P&Q, and it really goes to the question of approach.
It may be necessary for this court to review this court's decision in P&Q.
Yes.
That's the decision where the leading judgment was Lord Justice Peter
Yes.
Jackson.
And perhaps the best way to put it is to update the position as expressed by Lord Justice Peter Jackson.
Well, I wasn't expecting this. I don't know whether any other
Well,
party
Lord,
wishes to.
I did circulate it to council on Friday afternoon. I appreciate that's very late. I haven't heard an objection to it yet, but there may be
When
one.
you say update, do you really mean overturn?
No, my lady, I do mean refine, and perhaps I can deal with that. And this comes to the issue of what is meant by legal father at common law,
Right.
and the relevance of the term legal father. I think there's a separate argument about genetic father, but I'll come on to this in a moment. If one analyses the submissions made on behalf of respondents,
Right.
those terms tend to be used interchangeably somewhat.
Right. So is this just trying to search for your skeleton argument? Is this dealt with in your skeleton
Lord,
argument?
it's not dealt with the question of whether father means genetic and legal father is dealt with, and we do raise that as an issue in our skeleton argument. And I can direct my Lord to that if my Lord wishes me to.
Can I find your skeleton? Thank you.
And my Lord, we deal with that at paragraph 44 at 159.
So we deal with it where?
Paragraph 44, my lady.
159, you say. Yep. So the
Court
respondents
bundle.
argue that the ordinary natural meaning of the word father must be the legal and father. In our appeal, our father must be the father in fact and law. It must follow that from this that for the purpose of crime, there's no distinction to be drawn between the legal and genetic father, right? So that's your case.
Well,
There's no distinction to be
Lord,
drawn
what-
between the legal and the genetic father.
No, my Lord, what I'm trying to address with my Lords and my Lady is the proposition which is put forward on behalf of the respondents, in particular the Secretary of State in this case, is the meaning of father at common
Yeah.
law is straightforward.
Yes.
And that's what I'm going to
But in
challenge.
your
with you.
skeleton, do you challenge that?
I don't challenge it specifically in that way. It really arises out of the way that, for example, the Secretary of State has put the case in the skeleton argument. Of course, I didn't have access to that at the time that I prepared the document.
It can't be we're dealing with straightforward concept here, father, and how the law defines father. So it
Yeah.
doesn't turn on the way that one party or other puts it in the skeleton argument. The approach, and I think it's been well accepted in judgment, certainly in recent times in this court, is that father, as a matter of domestic law, means the genetic father.
Well, that's certainly one interpretation.
Oh.
But if you allow me to develop that
Well,
argument.
I'm just trying to work out
Yes.
whether this is coming for the first time
Yes,
in the afternoon of the first day, or whether it's a proposition that you have in your skeleton argument. I'd understood, the reason I'm
yes.
asking, I'd understood that you were accepting that the legal definition of father was
Well-
genetic father.
Lord, it's the way that it's put in the submissions made by others. We can go through it. So it's put variously that it must mean legal and genetic father. In some
Well-
submissions, it's put as it means the legal father. In other submissions, it's put as being legal or genetic
Some-
father.
Some fathers, as a matter of law, will not be genetically related to their
Yes.
child, the adopted child
Yes.
will have an adopted father who's not genetically related.
Yes, my lord.
And in surrogacy, there'll be a male parent
Yes,
has a parental order.
yes.
So I hadn't. So you're pointing to legal and genetic, meaning that you can be the legal father of a child without being the genetic father.
You can certainly be the legal father, but it really goes to, in the case of an unmarried father, whether the
Right.
genetic father is also always the legal father. So, for example, in Re-M, if that analysis is correct, then the legal father would be the unknown sperm donor.
Yes.
Yeah.
Yes.
Absolutely.
And if one extends that, and I'm sorry to use this as an example, I was going to come on to this, but what would be the situation, for example, if a child is the product of a rape? What would be the situation?
The circumstances are awful,
Yes,
but the father would be the rapist.
but does one also call that the rapist the legal father of that child?
Yes.
Does it follow that an incestuous relationship that gives product to a child, and that father is the legal father of that child, even though those acts are unlawful?
Yes.
Well, Lord, if
Well,
that's
that's we're nodding and
yes,
making some quiet noises, but that's the assumption that I had been working on that was accepted.
well, Lord,
So you want to take us to this address by Lord, this lecture by Lord Reed, which presumably doesn't deal with legal parentage.
no, not at all. It deals with. I would submit it.
I just wonder
Well, it
whether it's
demonstrates
whether I
a-
just
a
wonder
full-
whether it's sensible to let you take us to it
Yes, thank you.
without using the Latin de bene esse, and then we'll see where we get to.
So, Lord,
Are the other parties certainly in this room? Ms. Clements, you comfortable with that approach?
My lord, I'd say it's irrelevant to the point the court has to decide, but I've got no objection to Mr.
No,
Montague's
right. I'll subside, Mr. Mumtaz, and you take us to the.
So, Lord, first of all, it's at page 2 of the talk. And Lord, I would say that I would submit that these are uncontroversial comments by Lord Reed. And it's to do with the second paragraph. The process of development of the common law reflects the nature of its sources. Judges find in the sources principles which they apply, as I have explained. As new cases continually come into the courts and society evolves, the principles which are inferred from the cases are refined or qualified, and the law develops. So that's one principle. The second principle we get on page 3. Paragraph.
3,543, isn't it?
Yes, thank you.
Removing the static, is that where you want to see?
Exactly so, my lady, yes. Characterised by both continuity and change. And the same paragraph a bit further down, ultimately the courts were pragmatically concerned with what justice requires here and now. Any development of the common law in order to meet the needs of the present time has to remain faithful at some level of generality to principles derived from sources from the past. And lastly, on page 6, internal page 6, if I may. The last paragraph, 3 lines down, judges have to consider whether the present context is materially different, as there is otherwise a risk that precedent-based system may result in the ossification of the law.
Yeah.
So, Lords and my lady, even if you don't wish me to address the issue of legal fatherhood, there is, we say in this case, for the first time, an opportunity for this court really to look at the interaction, the relationship between the acquisition of parental responsibility and the meaning of fatherhood. And that specific principle or issue has not really been dealt with in any other common law authorities that my lords and my lady being referred to. So it does. So it does require one to step back slightly and to see and to observe what Parliament intended in the lens of the acquisition of parental responsibility, rather than through other lenses, for example, declaration of parentage or other issues, which, although we say are linked, are not necessarily decisive in terms of how parental responsibility is acquired and what the meaning of the word father is.
Forgive me. But
Yes.
I think you accept that the Children Act was enacted in the context of a clear understanding that father meant legal father or genetic father.
Well, respectfully, I would
Before
prefer.
you get into
I'm
the
so
more
sorry.
read things, that's the context. So surely what you've got to do is show us as a matter of statutory interpretation something which indicates that the use of the word father here doesn't mean what is normally or was normally understood by father at the time of the enactment. And at the moment, I don't. These principles that you've given us from Lord Reed are not in doubt, but they're not helpful.
Well, Lord, there are two distinct issues which you've already addressed with learned from Miss Briggs. One is what the meaning of father is and whether it would be a genetic father or not under the Children Act. And there is a separate issue about how that is evidenced for the purpose of an acquisition of parental responsibility. So what we say about that is Parliament has provided different thresholds for evidencing fatherhood. A good example of that, we say, is, if you'll forgive me for a moment because I'm jumping forward in my submissions, is the Child Abduction Act 1984, section 37, which we deal with at 153 in our skeleton argument, please. So presumably it would be said that the meaning of father must also be genetic and or legal father for the purpose of this section. And yet, for reasons which perhaps are understandable, they're defined somewhat differently here, that there are reasonable grounds for believing the father of the child.
Presumably either because the child's birth certificate.
Yes.
That simply means there's not been DNA to disprove that he's the father.
But
I don't think that shows a different definition of
well,
father.
it's not a different definition, milady. It's a question of different thresholds being required.
This is your second, but did you say
Yes.
the two issues? One
Yes.
is the father, genetic father, and second, how is that evidenced?
Exactly.
And you said
And here it's
Parliament has given different schemes
Exactly.
for evidencing.
Yes.
This is one.
Another example of that, which required, we say, Parliament to clarify, or at least the government to clarify the meaning of the word father, we find in the nationality regulations. And that should be in the authorities bundle, first bundle at page 60, please.
Page
60.
Page 60.
Thank you so much.
So I'm sorry, if we can start, in fact, at page 58. The 2006 regulations.
Yeah.
My lords and my lady can see there's reference to the father of the child at 2A. There's no precise definition of what the word father means under these regulations. Now, if father must mean the genetic father at all times, it's perhaps interesting to look at the revised regulations in 2015.
Just looking at the, just take my eye, 2006,
That's
regulation
2006.
2, the following requirements are prescribed as to proof of paternity.
Yes.
One is named in the birth certificate, or person must satisfy the Secretary of State that he is the father.
Yes.
And 3, Secretary of State may determine that he's the father by having regard to any evidence, but not limited, including but not limited to DNA tests or court.
Yes, my lord.
Yeah. So it's a way of proving that the person is the genetic father.
Well, here it says father. But if one then looks at
Right.
the revised
So
regulations,
what would the DNA tests prove?
they wouldn't. Well, but this is precisely my point. That if that was sufficient, if that was sufficiently
Right.
clear,
So I've got
Yes. if that was sufficiently clear, and it must have mean the genetic or
right. So
natural
we then
father,
go on, do we, to
we
to
go on to
2015?
2015, and the word natural is inserted.
Where are we looking now?
I'm sorry, at
Page
page
60.
60. I'm so sorry.
Is that
Sorry,
right?
page 60.
60, yes.
Thank
So
you.
these are the regulations in 2015.
So regulation 2 is substituted
Yes.
with the words that we can see there. The prescribed requirement as to proof of paternity is that the person must satisfy the Secretary that he is the natural father of the child. Right.
So the point I simply make there is if it was abundantly clear to everyone that it must mean the genetic father in 2005, why is it necessary to insert the word natural in 2016? So
Is it your submission that the previous regulations in fact applied to non-natural fathers?
well, Lord, this is one difficulty, and of course I will answer that in a moment, but our primary submission is it is for Parliament to decide what the meaning of father is, and in certain circumstances it has refined the meaning of father, this being one of them. So insofar as it's been necessary to further define or be stricter as a definition of fatherhood, it has done so. When in the Children Act 1989 the term father is used for going on 30 years without precise definition, we say there's a reason for that. It's for Parliament we submit to provide a stricter definition of the word father if one is required, particularly given the consequences of losing parental responsibility retrospectively. And what happens to fathers when they retrospectively lose parental responsibility? They act on their parental responsibility, and yet they're told subsequently that they never had it to begin with.
I'm looking at the explanatory note to the 2015 regs, which we've got on
Yes.
page 62. Quite a convoluted read, the first paragraph. And then the second paragraph, Regulation 3 amends the 2006 regulation so that subject to the transitional provisions, being named as the father on a birth certificate issued within 1 year of the birth is no longer a prescribed requirement as to proof of paternity. Instead, in all cases, relying on Section 50 to establish fatherhood, the person must satisfy that Secretary of State he's the natural father of the child.
Yes.
So they've, coming to this fresh, they've jettisoned the birth certificate as a requirement and simply said you've got to satisfy the Secretary of State
Yeah.
that you are the natural father. Yeah.
By way of DNA or court order.
Yes, but the DNA already existed in the previous
Previous regs, yeah.
2005 regulations.
But you can't reverse engineer that argument in order to say that 2006 is not talking about natural parents, can you?
Lord, I'm not trying to do it in that way. The core submission is, with respect that it's for Parliament to define what father means, and there is uncertainty, despite the fact that it's expressed as being certain, about that definition, particularly in the context of being a legal parent. Now, I'm going to move away from that because my Lord has identified that I haven't really dealt with that in my skeleton argument. If one concentrates on genetic parenthood, which is perhaps the most important aspect of it, leave aside the word legal, because I would submit that's somewhat controversial. Let's concentrate on genetic parenthood. Even if one accepts that that was Parliament's intention, it is for Parliament, depending on the context, the legal context, to decide how that is evidence and how that is to be proved. That's our core submission.
Yep.
So here, when one is looking at nationality, it sets out a clear and compelling procedure. That's what is required. Equally, we say if one looks at the complete statutory scheme under sections 2 and 4, that's what's been set out. And what you're being asked to do is essentially to go behind that, based on the common law definition of fatherhood.
In the Children Act, Parliament hasn't established how genetic parenthood is to be
Yes.
proved.
Well,
It
Lord-
simply said if the parents agree that he has got parental responsibility and he's the father, then he gets it. It doesn't deal with how you prove paternity.
yes,
It's looking at evidence of the agreement between the mother, who has parental responsibility always, and this unmarried father.
precisely so, Lord. But it's in the context of what does father mean when an unmarried father is going to acquire parental responsibility, and to what extent does one have to apply a strict definition of fatherhood, given the public policy behind, in particular, PR being acquired through being registered on a birth certificate. Now, one of the points my Lord made in the REA, and we can go to it if you wish, but I'm sure my Lord will remember, is that one of the purposes behind acquiring parental responsibility as a result of birth registration was to increase the number of fathers who could acquire PR. One of the reasons that there was the get-out clause, as it were, so that PR could be discharged from married fathers in the way that it's not available for married fathers, is to give mothers in particular some reassurance that, for example, it could be discharged. So if Parliament is intending to introduce measures to open out, to increase the number of fathers who acquire PR, it also makes sense for the procedure to be simplified and straightforward.
Yeah.
It would have been quite easy for Parliament to insist on DNA testing.
But Parliament was, as we know, it's against the background
Yes.
of the fact that many couples, families choose not to get married now.
Yes,
And so it's against the backdrop of the huge number of people who choose to live together
yes,
in a more informal but wholly committed relationship.
yes,
And so that was introduced so that those couples could, without having to have some sort of side deal, if I might put it like that those couple in their committed relationships could go along and register the birth together, and the biological father would be have his parental responsibility regardless of whether they're married or unmarried. Now, how do we say that we then have to, are you saying that we have to sort of expand Re-G and say that actually was to cover psychological fathers also?
No, lady, I'm not saying that. That would be a bold submission, and one I can probably make it at this stage, and certainly perhaps not even for this court to, not even perhaps for this court to decide on. Even if one accepts that Parliament was looking at genetic fatherhood.
Well, if your submission is not that the intention was to extend it to psychological parents.
No, I'm not saying that.
Right. In that case, then Parliament did intend it to be genetic fathers.
Well,
Because you either are or you're not. If you're not saying it
well,
goes
lady,
beyond.
I'll accept that proposition. Even if Parliament intended to be genetic fatherhood,
Yeah.
it's for Parliament to decide for the, and this is the key really here, for the purpose of acquiring PR, for that specific purpose, how that is going to be evident. So it would have been quite easy if genetic fatherhood was the intention. In fact, as I understand it, this was one of the recommendations, or at least one of the options given by the Law Commission, was to link the acquisition of parental responsibility to genetic fatherhood. That was one of the propositions that the Law Commission recommended we go to if necessary, in one of the skeleton arguments. So if that was so important, that would, or at least could, have been introduced instead, or perhaps even as well as, birth registration. the fact that we have birth registration indicates, we submit, that a simpler, more straightforward policy was at hand to encourage people to apply, fathers in particular, of course, to have parental responsibility with the caveat that it can be discharged. And that's really important here. Maybe perhaps it's somewhat overlooked. This is not PR which persists indefinitely, which cannot ever be changed. That get-out clause was put in for a reason, recognising in our submission that there was a margin of error, is the way that Ms Briggs puts it, and I agree, recognising that there was a margin of error, and at times that error may need to be corrected. And that's where 42A comes in. And Lord, if one, and my Lords, my Lords, if one then looks, please, at, for example, the direction of travel, if I can put it that way, the Secretary of State in their skeleton argument sets out the history of parental rights and parental responsibility helpfully. And we can see that we start off with the proposition that only a married father, not even the mother, has parental rights. Then we have a situation where mothers also acquire parental rights, parental responsibility, but not unmarried fathers. Then there is a statutory development when unmarried fathers can acquire parental responsibility through court orders and agreements. And then we have this later development. And it's important to recognise that it is a later development where they can also get it through registration. So we have a direction of travel towards increasing the number of fathers in particular who can acquire parental responsibility. And the reasons behind that are obvious in my submission. We have a prerogative to increase the number of fathers who fulfil parental roles for children. That's different to identity. It's different to strict legal or common law definitions of parentage or fatherhood. And if that is the policy behind, or at least one of the policies behind this increase, then one can see that if one insisted on proof of genetic parentage, which would be quite easy to do even in 2002. DNA testing was available, readily available. It's perhaps cheaper now than it was, but still. It might be, it might be said, no, I submit, Lord, that that could have decreased the number of fathers who could come forward, or would want to come forward.
Are you going to take us to the precise wording of section 4?
Yes.
I think if you're going to do that later, then we'll do it then. But I
So,
think it's
Lord, can I-
important to have that in mind.
Can I deal with it in this way? And I've rather jumped around. Can we look, please, at if father means genetic father throughout the Children Act, what the implications of that are? Because it applies to section 2, it applies to section 4, it applies to section 12. To some extent, it may apply to Schedule 1, although I appreciate there is a case on that which qualifies that. But can we perhaps undertake that exercise next? I appreciate I've got a little bit of time, but
Yes.
the primary submission is the consequences of the literal strict interpretation being advocated on behalf of the respondent Secretary of State are really quite serious when it is retrospective. It's one thing for the court to be told, from now on, this is what it means. But the decision that my lords and my lady being asked to make is that this was always the case. This is always the case, right from the very beginning. That throughout the Children Act, from the very beginning, it must have meant genetic father. One has to analyse what that means on a practical level.
It's been my understanding, it's not from the beginning of the Children Act, it's common law.
Yes.
That the father is the father, and the father is the biological father.
Yes, but in terms of course, that's right, my lord, but in terms of the acquisition of parental responsibility, and in particular the acquisition of parental responsibility by unmarried fathers, that is a creature of statute.
Yes, but they're two different. I wrote down that you were accepting that Parliament intended the definition of father
Yes.
to be the biological father.
Yes.
whether or not that individual acquires parental responsibility is a different undertaking.
Yes, but even if I don't want to repeat my point, but even if that is accepted, one has to look at what the implications of that are going to be.
Right, well, is that what you're going
Yes,
to do?
that's what I'm going to move on to, if I may, please. So if one can start, please, by looking at section 2, and we find that
Starts at page 93.
your Lord is ahead of me. Yes, 93, please, thank you. So dealing with, first of all, married parents, section 2.1, the child's father and mother were married. So if the married father was not, or has never been the genetic father, does that also mean, as a matter of logic, that they do not acquire parental responsibility?
They don't want.
Do not acquire parental responsibility under section 2.1.
Sorry, could you say that again,
Yeah.
please?
So, my lady, looking at the wording of section 2.1, parental responsibility for children, where a child's father and mother were married to, if the word father there must mean genetic father, if the married father is not the genetic father, does it follow, therefore, that he does not acquire parental responsibility under section 2, irrespective of what the common law says about that?
Well, if he's not the father, he doesn't come within section 2.1.
So this problem of retrospective discharging of PR, and as a matter of logic, will also apply to married fathers, not just unmarried fathers.
Well, we've got the presumption, which we'll come to. I've got where it is, but there's a presumption that he is the father if they're married.
But how does that, Lord, I asked the question rhetorically somewhat, how does that really square with someone who's not the genetic father? If this means genetic father, surely it must mean genetic father whether you're married or unmarried. How does the presumption help us in that way?
Because you presume that he's the genetic father unless it's proved to the contrary.
If it's proved
So
to
it
the
was-
contrary, then that's it. He's never had PR.
He's not the father.
So at what stage is that presumption then engaged? So for example, we have the Brearley case, we can go to if you wish, but you'll may be familiar with it, where it's pretty clear on the facts of the case, the married man could not have been the father because separated from the mother. It was physically impossible. So at what stage is that presumption engaged, and what is the mechanism through which that presumption is engaged? It's not for me to ask questions, but
No.
I'm just challenging this idea that there is a different approach between married and unmarried fathers if one applies a consistent meaning to the word father in the Children Act.
But there is a different approach because Parliament seeks to enhance the status of marriage by the presumption that where a couple are married, the husband will be the father.
Well, let's move on to section 4 then, if we may, and in particular section 4.1c. And this is the court making a PR order in respect to the father. Now, does this then become a jurisdictional issue for the court? Does genetic fatherhood have to be established before the court can properly make an order? Because at present, Lord, although I accept that in some cases parentage is challenged by one or other parent and a DNA test is ordered within proceedings, that's not always the case.
But
Is there a jurisdictional issue here for the court? If the court is going to...
If it's raised.
Well, my lady, we're then left in a position, aren't we, that there is a similarity between factually those two situations, between presenting at court and saying this man is the father of the child, an order being made, and presenting before a registrar and saying this man is the father of the child and birth being certified.
This is private law. This
Yes.
is Parliament providing a structure for private individuals who have a child in their family unit
Yes.
to regulate their arrangements in a straightforward way.
Yes.
If a couple come to court
Yes.
and she says he's the father and he says, yes, I'm the father,
Yes.
the judge says, well, no issue about that. The question is, under section 4.1c, should the court make a parental responsibility
Yes.
order for him? So the court's not going to say, no, I want to have genetic testing here, not so fast, Mr. Smith. We'll adjourn it for DNA test. The court's not going to do that. So as between the parties, the private couple who want to have arrangements with their children, they're accepting that they come within the subsection, and the issue is, does he get the parental responsibility or not?
Yes,
If he's not the father,
yes.
then certainly the respondents would say that the court order has no effect because the court couldn't have made an order to someone who's not the father.
Well, I'll wait to hear with interest what the
Yeah,
respondents say
but,
about that. Certainly the Secretary of State.
Fortunately for this court, those circumstances don't arise in these appeals. We're not looking at a court order where the court's decided that he should have a responsibility and whether then that order subsists until it's set aside. Here, there's no order that goes to the void ab initio. If a court makes an order in another context, it may be void or voidable, like for example, a decree of divorce may be void or voidable in certain circumstances. But in the circumstances of registration on the birth certificate, there's no court order being made. There's nothing void. The birth certificate is the birth certificate. The birth's been registered. It's the consequences of him being named in the birth certificate as to whether or not that triggers parental responsibility.
Well, I accept all of that. The point I'm trying to make, perhaps clumsily, is that if one looks at this section, there are three mechanisms for an unmarried father to acquire parental responsibility. One is through a court order. One is through registration. Parents could present exactly the same facts, and depending on what the respondents say, certainly my understanding of the Secretary of State is that if the order is made, it is valid until it's discharged. If it was a court order, the father would continue to have parental responsibility until it's discharged. If there isn't a court order and it's through registration, then he never had parental responsibility to begin with. So applying that definition causes problems, and this is why I go back to my primary point, which is it is for Parliament to determine what father means in that context.
Why does the fact that there's potential difference between how the parental responsibility plays itself out mean that there has to be clarity as to what Parliament meant about the definition of father?
Well, Lord,
The definition of father would be the same in all the circumstances, but there's a difference, you submit, between registration on the birth certificate or the court making an order for parental responsibility. They're one stage further down the line from the establishment of fatherhood itself, or the definition of fatherhood itself.
Lord, it's difficult to deal with this word certainty. My understanding of the respondent's argument and that of the Secretary of State is that if one applies the common law principles here, and in particular about genital parental, it produces certainty for everyone. That's a better way for the court to approach this. Everyone knows what the natural ordinary meaning of the word father is. If you apply that to Children Act, it creates certainty. That was the intention of Parliament. What I'm trying to demonstrate is that is not necessarily the case. And there are problems with approaching it from that lens. And one of the things perhaps we have to be aware of, Lord, respectfully, is this, that we are dealing with, in this court especially, quite rare factual situations. You can see that, for example, the circumstances in Re P are extremely rare, or even perhaps the circumstances in Re M are relatively rare. One has to also think about what this means for everybody who doesn't come to court, who doesn't need to come to court to get an order, who there's no reason for them to challenge paternity on the face of it. So, for example, I asked in my skeleton argument, if one extends this to parental responsibility order agreements, and my lords can see that on the face of the parental responsibility agreement, the participants are advised to get legal advice. Now, if it is correct that genetic father must only mean, for the purpose, again, I reiterate, for acquisition of parental responsibility, must only mean the genetic father, then is that advice going to be, you have to get DNA testing if you want to be assured that you've got PR under an agreement? Because sensibly, I submit, that can be the only advice that can be given to someone.
No. The mother can be given advice. You do understand that they want to get parental responsibility, has parental responsibility, and that gives him certain rights and duties. That's the sort of thing the mother might be told.
Yes.
She wouldn't necessarily be told you better go and have a DNA.
I'm sorry,
Someone might
lady, yes.
suggest you've been having an affair.
No, you're quite right. I don't mean to extend it. Certainly fathers would need to have some advice given to them as to certainty when it comes to biological parentage, in my submission.
Don't you also want to encourage trust as between the man and the woman?
Yes, but that really goes back to my point, my lord, that by the encouraging trust is actually reinforced by having a simple mechanism where all that is required to acquire parental responsibility is for that mother and father to present to the registrar and say, this is the father, jointly. That encourages trust in my submission.
It's not how I see it.
Very well. Lord, I appreciate that the facts of our case re-em, in particular in relation to dishonesty, have put some of these submissions in different context. And the dishonesty is going to be viewed unfavourably by the court at the very least. But also one has to operate in the real world. If one looks at the facts of this case, although certainly the court won't endorse this, the reason behind, my client says, certainly the appellant says, that the circumstances arose whether they went to a sperm donor was that they did try to have a child for a long time. They even went to IVF. That didn't work. They spent a lot of money on it. And he always regarded himself as the father of his child. Now, of course, legally that is incorrect, or maybe incorrect. But that's the context in which the dishonesty, insofar as it's termed, took place in this case. And there is a remedy. There is a remedy. The remedy is section 42A. And the real advantage of 42A is we don't have the prospect of what Ms. Briggs has called illusory PR persisting. And if necessary, where there has been sufficient dishonesty allied to the child's welfare, then the PR can be discharged.
Yeah.
Lord, may I just briefly deal with some of the public policy arguments
Yes, please do.
we raise? Sorry, just one brief point on section 12. Again, I submit that if one looks at section 12 of the Children Act, it's at 127. Then where the word father is used, again, one has to insert genetic and what that means. And Lord, the broader point, of course.
Well, I think we just need to do that.
Yes,
We
sorry.
need to understand what you mean. So section 12(1), for example,
Yes,
where the court makes a child arrangements order,
yes.
the genetic father of the child, or a woman is named in the order, and the genetic father would not otherwise have parental responsibility.
Yes.
So what's wrong with inserting genetic in our minds when we're reading that?
Well, my Lord, it limits under section 12 how parental responsibility could be acquired.
Yes.
So, for example, the only real way it could be acquired would be if the child lives with that person, then they shall have parental responsibility. And if the child spends time with that person, then they may have parental responsibility.
Yes.
But again, this doesn't, I'm so sorry.
Sorry, that's plainly what Parliament intended to achieve. It doesn't shed any light on the definition of father, does it?
Lord, perhaps I'm expressing myself.
Yes,
It's not the definition
maybe
of
me.
father that I'm getting at. Even if one accepts it means genetic father, it's whether that creates problems in the interpretation of other sections of
But
the Act.
what are the problems?
The problem here is it limits.
But the
The-
Parliament plainly intended to this section 12 came in to replace residence orders and
Yes.
contact orders, and my understanding is that as the court will know, under a residence order, the holder of a residence order, whether they were the father, auntie, Mr. Blogs from down the road, was given parental responsibility.
Yes.
Under a contact order, they didn't automatically get parental responsibility.
Yes.
And this aims to replicate that. If subsection 1, if the child is to live with the person and they wouldn't otherwise have parental responsibility, then the court will make an order giving them parental responsibility. If they're spending time with, then the court may give them parental responsibility. That's what it is. It's intended to structure and limit who gets parental responsibility, if the yardstick is how much time are they spending and in what circumstances are they spending it with the child.
Yes, the only restriction is that the definition of genetic father means that that person cannot get PR through the other subsections. That's the point.
Well, I haven't gone into this, but if it's granny who's getting a lives with order, there are other arrangements. So it's 2A, child arrangements order, and the person isn't a parent and is named in the order. Then there's provision for parental responsibility there.
Well, so it's really
So
so under section 1, a genetic father, sorry, non-genetic father would not qualify.
no, under section 1, they'd come under section 2.
Yeah.
So subsection 2, where the court makes a child arrangement order and the person who is not a parent, so
Yes.
not the genetic father, is named in the order as the person with whom the child's to live, that person shall have parental responsibility.
Nor would
So
would
both
that person-
categories of men, if that's what we're talking about, father, genetic father or non-genetic father, but a man who's taken, like your client, on the role of being a parent, would get parental responsibility if they have a lives with order.
Yes. But if it's a spends time situation, then it's
Yes,
an A rather than
different,
shall.
yeah.
Well, the broader point I was going to make, of course, this would not apply to the appellant in re, because this would not apply when there was a care order in place.
Yes.
So although this does provide some amelioration for some people, it would not provide any for someone whose child is subject to a care order.
Yeah, I understand. Yeah.
Well, may I move on to the public policy arguments, because I
Yes.
appreciate
Now,
time is short.
you shouldn't feel you've got to finish at 4 o'clock. My watch says we're 6 minutes to 4. So do you want to start this for 6 minutes or so, or start it tomorrow morning?
Well, may I start?
Yep.
We can make use
But
of the
then
time.
I will be quite precise at 4
Yes,
o'clock,
of course, I'll
simply
stop.
because there's a
I'll
good
make
reason.
sure that I stop
Yeah.
at 4. Lord, we deal with the public, what we say are the public policy arguments in our sketch time. I'm not going to repeat those points, but just to use one example, and that is the appointment of a guardian under Section 5 of the Children Act. That was, in fact, one of the examples that we gave in our submissions to the first instance judge. And if one looks, please, at Section 5, and I think those are pages 98 to 99.
Yeah.
And in particular, in our submission, if one looks at subsection 3 and subsection 5, it is possible for a person with parental responsibility or parental responsibility to appoint a guardian without any involvement from the court, or at least a judge.
subsection 5.
Yes. Thank you. And briefly, if I may, I've tried to think carefully about what the remedies might be under the Children Act, because that's one thing which is said against us. There may be remedies against us to address this issue. And one can see perhaps in a similar way to prohibited steps orders being made when a married father has PR to restrict that. It could be said that the court could make a prohibited steps order preventing a person from appointing a guardian, I suppose, in advance. That would be difficult because one would have to know that there is an issue to begin with in order to address the problem. But it doesn't, in any event, deal with appointments that have already happened.
So just make sure I've understood. So this subsection 3,
Yes.
a parent, father, a parent who has parental responsibility may appoint another individual to be the child's guardian in the event of his death.
Yes.
It turns out that the person isn't the biological father.
Yes.
So he isn't a parent.
Yes.
Is your point that that individual may believe that they are, may have been registered on the birth certificate, and may therefore, on your case, have parental responsibility. They appoint someone as a guardian. They then die some years later, or they then subsequently die, and it turns out they weren't the father.
Yes.
So is your point that
What happens to
what
that
happens to that
guardian?
appointment? Because you say they had parental responsibility at the time they signed the.
On our case,
Is that
yes,
is that
yes.
the point?
On our case, that person would have parental responsibility even if he's not the biological father, and therefore the appointment would be valid. On the respondent's case, he's never had parental responsibility, so query is the appointment valid at all?
If
so
sorry, if the deceased isn't the father, it would be wrong for him to be appointing someone to be the guardian. He's got no standing.
Well, that's of course is right if one starts now, my lord. But if we go back retrospectively, that person might not have realised that he is not the father. He might genuinely have acted thinking he had parental responsibility, knowing, for example, that there's ill health involved and shortened lifespan as far as he's concerned, and acting appropriately to secure the child's future. But on the analysis given by the respondents, it casts doubt as to whether that is a valid appointment to begin with because he didn't have PR to begin with. And what if the guardian then takes decisions in relation to that child? What is the status of those decisions?
But I think the respondent's case is the fact that he may or may not think he's got PR at the time, may not have active PR at the time, isn't the point. If he's not the father, he can't be appointing, not in fact the father, he can't be appointing a guardian.
Well, legally,
the PR is the ticket by which to appoint a guardian if you're the father.
But what he has acted in good faith, thinking he is the father.
It's awfully, these are tragic circumstances you're describing. But legally.
Ms. Montes,
yes.
I mean, I do think we do try in the family world to be reasonably practical.
Yes.
And if a father, psychological father, thought he had PR and does this, well, if it comes out after his death that he was not in fact the genetic father, that would be because someone had challenged. That would be because someone has said, this person should not be the guardian, or he was never the father, I always knew he was the father.
Yes.
And so from a practical point of view, if it turns out that they're not responsibility, if that's the conclusion the court ultimately comes to, that will be because there's a whole upset which has to go before the court in any event.
Well, yes, I see the time. Perhaps I can come back to this tomorrow morning if I need to.
Saved by the bell. Good. So 10 o'clock tomorrow. Thank you.
Court rise if able.